truly is a treat, and I really said, sorry it took us so long to have you here. We really look forward to your talk. Thank you.
It's really wonderful to be here. I want to check again. You can hear in the back? Yes? Everything's good? If you get to a point where you don't want to hear in the back, just signal, and I'll just shut myself down, all right? So it'll be good. I'm wearing 7 or 8 microphones because this is the first day they've done new technology in the room. So if partway through I self-immolate or blow up, it won't be something that's part of the act. It'll just be something, and then the dean will come up and clean up the residue. It's really, you recycle, right. I saw the thing for compost here in the men's room, so I figure I'll end up in the compost pile. So it's great to be here. My sister is here, Ann Petrila, and it's always wonderful to see family. I've had the great opportunity over the last few years to spend some time with Dean Williams. Those visits, when we've been hanging out together, usually, in fact, I would say always, involve really good restaurants and wine, so that's always a treat. So I'm very happy to see Dean Williams. I also know that under his leadership, not just for the food, also the wine and the dessert, under Dean Williams' leadership, I know the school here has really sort of ascended the ranks in terms of rankings of schools of social work around the country. I think that's remarkable in part because as a private school, given tuition and everything else, the fact that you can continue to draw good students, the fact that you can continue to ascend the rankings is remarkable. So I congratulate you on that. As an older brother, I would be, and as also though as a chair of a department that understands and appreciates how important it is to our students to get placed in good placements, I would attribute at least some of that, I believe, to my sister Ann. So, all right, so we're going to talk about several non-controversial topics today. We're going to talk about health insurance, we're going to talk about abortion, we're going to talk about legal, for now, marijuana, and we're going to talk about same-sex marriage. 2 of these cases, same-sex marriage and the health subsidies, Supreme Court has heard the health subsidy case, will announce its decision in June. They hear the same-sex marriage case shortly. It is very likely, depending on sort of composition of the court over the next year and a half, that the court eventually will accept a case that will determine whether abortion rights are returned entirely to the states, whether restrictions are permissible under the current court that effectively end abortion access in many states, or whether they preserve what's left of the status quo. So we're going to talk about these things. This was a headline from the New York Times a few weeks ago. Gay marriage begins in Alabama, only in parts. The Alabama Chief Justice reaction, this is a quote, father-daughter marriages may follow. Because as a sort of a, when one thinks in a linear fashion, just relies entirely on deductive reasoning, it clearly is the case that if there's same-sex marriages, it will lead to father-daughter marriages, as it has in all the states that have legalized it so far. So, here's the state of the law, just to set this up. On this side, all these states here, gay marriage was outlawed in October 2013. All these blue states, 15 months later, is where same-sex marriage is now legal. Now, was that just that state legislators got this epiphany around the country and said, we need to legalize same-sex marriage? We've always been disgusted with our oppression of people who are gay, and so we're going to have an epiphany, and all of a sudden, all these states passed it. Having grown up in Indiana, which is now the poster child for tolerance, in light of its recent legislation, I can say the answer to that is no. That what happened is this, and I'm going to talk a lot about the Supreme Court today. Everyone knows there's a U.S. Supreme Court, right? And the Supreme Court would be, in terms of a hierarchy, which court would it be in United States law? Supreme. So, I mean, this is good. This is why the School of Social Work continues to rise in the rankings. So there's 9 justices on the court. This is Justice Ginsburg on this side, trying to get us far away from some of her more conservative colleagues and still be in the frame. But it really comes down of 9 justices to these 2 justices, Justice Kennedy and Justice Roberts. And so one of the points I want to make, if you leave with nothing else, And assuming I get through the whole talk without blowing up and burning up and becoming compost, which in Indiana is big, so I mean, I would be returning to my roots. If you get nothing else, it's that on some of the core issues in terms of population health in the US, A, some things that have been articulated as rights are in fact very precarious, and B, there's nothing more important than the 9 justices on the Supreme Court, and these 2 justices in particular, for reasons that I'll talk about. So I'm going to talk about 4 things, as I said. I'm going to talk about gay marriage, same-sex marriage. I'm going to talk about what people who are now advocates for this issue nationally say I should refer to as cannabis instead of medical marijuana. But I grew up like a long time ago when it was just marijuana, so I don't know. This is health subsidies. I'm going to talk about what is possible alternatives or outcomes with abortion. If you have a question at any time, feel free to holler. If you have a good lawyer joke, anything, let me know. Restaurant recommendations are also welcome. So, this is a great little sign. In Colorado, marijuana got more votes than Obama. Fox News is trying to figure out what this means, because they know it means something and it can't be good. It's part of the apocalypse is on the verge of coming. I think Fox would attribute it to Americans like marijuana more than they like Kenyan presidents, but that's a different issue. But it shows the power of this vote. In Florida, medical marijuana was on the agenda, on the ballot. In Florida, you have to have 60% of the votes to pass a constitutional amendment. Because of a constitutional amendment several years ago that didn't pass by 60%, but such as it is, medical marijuana got 58.9%, so it fell short. The legislature, because it's a right-wing conservative legislature, and I say right-wing with all respect and not any political judgment, the legislature in Florida is gerrymandered in terms of the way districts are drawn so that the legislature is fundamentally way to the right, given that President Obama took Florida twice in the popular vote. So part of the other point of this is things we may or may not take for granted are affected not only by the Supreme Court, but how legislative districts are drawn. And sort of is a legislature, in fact, which is more often the case over the last 10 or 15 years, more conservative than the state in which it sits. And that's a major issue as well. So, same-sex marriage, 4 questions, or 3 questions. First, does the federal Constitution create a right to same-sex marriage? You can read the Constitution all day and never find the words marriage, abortion, privacy, cannabis, or anything else. But we're dealing with textual phrases, constitutional amendments passed after the Civil War to deal with slavery, to give people voting rights. And the question is, does that Constitution, as the justices read it, create a right to same-sex marriage? Second, must states recognize same-sex marriage? This was the Alabama sort of Supreme Court chief's reaction. He said to clerks, don't enforce what in that case was a federal court order. And then, will discrimination on the basis of religion be permissible? And I'll come back to this, but this is what I think is a fundamentally radical notion that now has become part of our constitutional law, that corporations have the same rights to some degree as people. And this is the Hobby Lobby case, the contraception case. This is the argument in Indiana that it's okay if we don't serve people based on sexual orientation because it's our religious rights. And so that's my favorite thing about Indiana was the pizza parlor that went on national TV to announce they would not cater a gay marriage, to which the response was, what gay couple would have pizza at their wedding? So that was like that was kind of cool. And then the court hears, on April 28th, Supreme Court hears these cases from 4 states. And the Supreme Court will decide definitively, in a decision they'll probably announce in June, whether the Constitution creates a right, and I'll come back to sort of the basis for why it might matter. Now, why does it matter in terms of health? You folks know this stuff, but it matters in terms of access to health benefits. It matters in terms of adoption. It matters in terms of surrogate decision-making. In Florida, for example, the health law lays out if you don't have an advance directive or a living will, a hospital can go to 6 different parties, and it creates a hierarchy for surrogate consent, so you don't have to go to court. First is spouse, And eventually, fifth or sixth is a friend who knows your situation well. If same-sex marriage is recognized, a friend who knows your situation well will probably rise, then you have the same rights in terms of surrogate decision-making for health care for your partner as, because it's based on marriage. It's relevant to estate planning, and certainly there's human dignity and equal rights issues. But in terms of population health, this is a big case. The background to this actually goes back to a Texas statute which criminalized sodomy, but only between same-sex couples in its approach to law. That case, which I'll come back to briefly, because it really is, you sort of think, where do these issues start? How do courts eventually find themselves where they end up? It started with that case. But the real case is the Defense of Marriage Act, which President Clinton said was the worst thing he did as president. I'm thinking it wasn't necessarily the worst, maybe second. But for those who remember, the first, it's like Game of Thrones. We have the Bush house and the Clinton house, and eventually we'll name all the Bush and Clinton presidents with Roman numerals like Super Bowls. But the first President Clinton signed the bill. These folks were married legally in Canada. After Thea Spire's death, after she died, Edith Windsor claimed the estate tax exemption for surviving spouses. It was prohibited by Defense of Marriage Act. So this was a tax case in which a person was denied the benefit of tax law, federal tax law, based on the fact that they were in a same-sex relationship that the federal government banned because it was icky. So this goes to the Supreme Court. Justice Kennedy, whose name I will talk about a lot today, you will remember, if you know no other justice on the Supreme Court by the end of this talk, you will remember Justice Kennedy. Kennedy says this: the federal statute's invalid for no legitimate purpose, overcomes the purpose and effect to disparage and injure those whom the state by its marriage laws sought to protect in personhood and dignity. It's a deprivation of liberty. So Kennedy says on constitutional grounds, the federal statute has to pass. It's a 5-4 vote. It's a split court. This court is split more often than any court in our history, at least since the 1930s. And Kennedy couches this in constitutional terms and talks about human dignity. Now, the thing to remember, and I always try to emphasize this to my students, marriage is lots of things, but in large measure, it's a legal status conferred by the state. Being a parent is many things, but in large measure, it's a legal status conferred by the state. So it's, again, sort of this issue of, is marriage going to be recognized in this context? This was the criminal sodomy law in Texas. It was entirely coincidental. This involved a black man and a white man when they were criminally prosecuted for engaging in consensual sodomy in their home, and challenged it on the ground that if you have to live in Texas, it can't possibly be this bizarre. And so this goes to the Supreme Court, and Kennedy says the petitioners are entitled to respect for their private lives. The state cannot demean their existence by making their private sexual conduct a crime. Now, if you think of the origins of this case, back to the early 60s, the first real case that started to articulate a right to privacy, which ended up ultimately in Roe versus Wade, which is relevant to this case, which is relevant to a large number of sort of these types of issues. Connecticut, back in the early 60s, made it a crime for a married couple to have contraceptives in their home. So that's where the Supreme Court's taking on cases that involved privacy, sexual conduct between consenting adults, et cetera, began. So we've gone really over 50 years from a case, again, in which you could be prosecuted in Connecticut for having contraceptives in your home to this, ultimately, the issues we're dealing with now. Justice Scalia, who can always be counted on for a sarcastic remark, and this is, I mean, I know you can read this, but this astonishes me. Today's opinion is a product of a court, which is the product of a law profession culture. No one I know who teaches law realizes there's a law profession culture, but so it is. This largely signed on to the so-called homosexual agenda, by which I mean the agenda promoted by some homosexual activists directed at eliminating the moral opprobrium traditionally attached homosexual conduct. The court has taken sides in the culture war, et cetera, et cetera. So this is Supreme Court justice. So this is sort of the stakes on the court. And these issues, I mean, I think you need to understand, these issues divide the court in terms of moral and cultural norms that the justices adhere to as much as they divide society. So there's not a rule book that the 9 justices go to and go, well, let's look up section 14.6 and see what section 14.6 says we should do about same-sex marriage or criminal sodomy statutes. These are deeply held beliefs on both sides of the court that affect all the issues that we're talking about today. So my prediction, this is great because I will go on record as predicting a number of things. I will expect to have, and send these to my sister, not to me. Your brother said the court would do A, B, C, and D. He was wrong about A, wrong about B, wrong about C, spectacularly uninformed about D. But I think it's inevitable. And Justice Thomas, who is with Scalia in terms of thinking this is just I mean, they really do believe this is a grotesque development in American law, that the court will announce that there's a constitutional right based on this reasoning, that there's no sound, rational basis to distinguish between couples in awarding the legal status of being married based on the sexual orientation of the couple. Now that's a radical departure from years and years and sort of decades of American law, right? And I think one of the interesting things when you look at public opinion polls on this is that, in fact, public opinion has moved pretty rapidly on this issue. That the number of people in lots of different places who accept and endorse the principle of same-sex marriage has risen exponentially over the last few years, as is true with medical marijuana. But I think in the end, the court is likely to do this. The question is going to be, if you have questions about this, I can go into more detail. The question is going to be, will the Hobby Lobby case, which is a contraception case where the Supreme Court said businesses did not have to provide, based on the religious beliefs of the corporation, 4 types of contraception, which were deliberately chosen because they could be characterized sort of as vaguely in the ballpark of abortion, that the question will be, what's the balance then ultimately between this expanded notion of religious freedom for corporations that the court articulated, which Justice Kennedy endorsed, and then same-sex marriage? Because the logic of this decision, if in fact this is what the court does, and the court can't, they've had opportunities to stop this train before. And after the court refused to overturn the Alabama ruling made by a lower court, Justice Thomas said, clearly there's a majority on the court that's going to legalize this, because now there's 37 states. You can't all of a sudden invalidate thousands of marriages without some chaos ensuing. The question really then will be this, all right? So that's part one. The thing to be reminded of is this: segregation now, segregation tomorrow, segregation forever. Religion has been used repeatedly to justify discrimination. These gay discrimination laws are not new in terms of American life. What used to be the case was it was used to rationalize racial discrimination. You can find scores of quotes from governors, Supreme Court justices in southern states saying, God intended the races to be kept apart. This is God's will. These are Ku Klux Klan guys going into a church just get tooled up before they go out and exercise their rights to religious freedom. This is a drinking fountain, white, colored, straight, gay. It's the same stuff in my view. Now again, you may or may not share that view, but I think it's impossible to view what's going on now as detached somehow from our history. That religion as a rationale for discrimination has always been part of American life. Religion was, years ago, a century ago, used to discriminate against Catholics, for example. That's religious discrimination. It was used, obviously, to discriminate against Jews. If you're practicing Muslim right now, that may be a little funky for you. So this is not particularly new, but that's sort of where we are. So that's issue one. A quick tour through 50 years of Supreme Court trying to sort out sexual orientation issues and what it thinks of it. Question two, this is a huge case. This is the Super Bowl, because I know in Denver you like to think you're going to go again, but it's not going to happen. I have to say, watching Peyton Manning throw passes like I would throw, it was not a...
We're going to move along here.
Who's to say I don't throw good passes? I mean, you can't. You see now, see how quickly this is part of what we're talking about, stereotyping. You instantly assumed I throw these little duck things. I throw them straight, 50 yards spiral, just like Peyton used to. So this is the Super Bowl of the Affordable Care Act. If the government wins this case, the Affordable Care Act will become part of the fabric of our law, just as Medicare had to survive years of dispute. The American Medical Association, which would now march on the Capitol if Medicare was repealed, opposed Medicare as they said this. It was a communistic way of funding health care. So I mean, any big shift in health care that involves the government gets a lot of sort of criticism. So this case, how many of you have heard of that? How many of you know there's these subsidies for health insurance? You've heard of it? How many, most of you, have your students heard of the Affordable Care Act?
Oh, yes.
All right, so you guys are right up there. Between this and the Peyton Manning thing, I'll be out of here by about 11:40. So, have you had a speaker chased out of the room before by the audience?
No.
But are we close? We're getting close.
You're doing good.
Okay. So here's how the health subsidies work, because it's somewhat complex, right? So it's controlled by federal poverty level, which much of the Affordable Care Act turns on. So if I'm within a particular range of the federal poverty level, I go to a health insurance exchange to buy insurance, and the policy's $8,000, and the ACA caps my expenditure at $3,000 because of where I fit in the FPL. The subsidy that is at stake in this case, the federal government writes a check to the insurer to make up the difference. That's the subsidy. Some people think it's giving poor people money and then they'll spend it on like stuff they shouldn't, instead of just white bread and like little frozen food to eat. It's a subsidy to the insurance company to permit the person to buy insurance. So that's the mechanism. It uses the tax code. So it's basically, and this statute is 42 million pages long. No one's ever read the whole thing. Here's what this case, upon which 12 to 15 million people's access to health insurance depends on. The statute says you get this subsidy to someone enrolled through an exchange established by the state under the ACA. That's the entire case. If you gave this exam question to a first-year law student, they would say, you look at, first of all, the statute as a whole, you look at context, you look at plain meaning, and clearly, this is a law school 101 question. Clearly, they didn't just mean the state, it meant exchange and blah, 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 blah. But it's this language, and this is a typographical, they didn't copy and paste and federal. If this read through the exchange, an exchange under the ACA, there's no case. If it said through an exchange established by the state or federal government under the ACA, there's no case. Only this language has created this case. And this is the reason it matters. Far fewer states, even states that have expanded Medicaid, have tended to punt on establishing the exchanges, and they've relied on a federally established exchange. So all these states default to the federal exchange, which means if you've enrolled for health insurance through a federal exchange in all these states, your insurance is at risk under the subsidy case. So the most conservative estimate by the Kaiser Foundation, which does the best work on the ACA, 11 million people will lose health insurance. People talk about a death spiral. Now, what does that mean? What has happened under the ACA is three different things. One is more people have been enrolled than was assumed would have happened. Second, part of the reason for that is more commercial insurers have come into the market to sell single and family insurance than people predicted, because people predicted commercial insurers would withdraw from the market under the ACA. And then third, the thought is if you take 11 or 12 million people out of that pool, the commercial insurers at that point will pull out of the market, because then they're going to have to raise the rate so high to make up for those left in the market that they're not going to be able to afford it. So that's what people mean by the death spiral. Hospital Corporation of America, which is the biggest hospital chain in the country, formerly headed by the governor of Florida, Lord help us. So And so people don't typically think, if we want a left-leaning view on a health issue, let's go to Hospital Corporation of America. I mean, they're a for-profit company designed to make business. They own hospitals all over. They filed a brief in this case. They characterized the arguments against the subsidy as absurd, and they said that by their reckoning, by the people who get care through them, the ACA has been a spectacular success. Every chamber of commerce that filed a brief in this case came out in favor of the subsidies on the ground that it's working. And again, whatever you think of the ACA, at some point it's useful to think about facts. And from the point of view of these big businesses, the ACA has been a great success. Now, part of the reason it's been a success, they get patients. They make a profit, but that's what they do. And so it's been interesting how this is lined up. The arguments against the exchanges have external briefs tend to have been filed by conservative think tanks, et cetera. Yes, sir.
So in both of the examples so far,
yes,
the same-sex marriage as well as this now, there's a sense of if the court, goes a certain way, in this case, 11 million people are
yes,
going to be impacted,
yes,
probably more if it all goes through this death spiral. To what extent, all of us have had Civics 101, they know about the independence of the court, their lifetime appointments, all of that. But to what extent, from your perspective, do they really look at this in terms of impact on the population?
Well, I think in terms of this case, as far as the oral arguments, Justice Kennedy, who I may have mentioned before, asked a question about this, and he said, will this not cause, so I mean, at some level, it's in his mind, right? So one of the other things that people surmise was in Justice Roberts' mind when he sided with the moderates in the court to uphold the ACA was, if you're a Chief Justice, and we've only had a handful, at some level you think not about population health possibly, but you also think about the first line of your obituary. So if you're a Chief Justice, do you want the first line to be Justice Roberts, who destroyed the Affordable Care Act based on a decision that was reviewed as highly partisan, et cetera, et cetera. But clearly this issue of impact on population was an issue in the Supreme Court. Now they won't decide it explicitly on that ground, but it clearly came up in oral arguments. The other thing though that's happened, and it's not, I think we sometimes think this is the most politicized time in our country and every blah, 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 but if you go back to the things Abraham Lincoln was called, if you go back to the split in the country when the Supreme Court became highly politicized during, when they were invalidating all Franklin Roosevelt's decisions. This is not the first time we've had a highly divided court. What's different is this is the first time over the last few years where news media will identify whether a judge was appointed by a Republican or Democrat. So the courts are at a greater risk of being politicized in the public mind than they, I think, have been. And so there's 5 justices appointed by Republicans on the Supreme Court. They tend to vote as a block. Does that mean they're voting the Republican line? I mean, not necessarily, but that's a different angle to the conversation. But they clearly, in the oral argument, considered this stuff, at least a couple of them. Again, this was what Justice Roberts said when he upheld the ACA. The Constitution permits such a tax. It's not our role to forbid it or to pass on its wisdom or fairness. What's more at issue in terms of your question and the court is relationships between the court and Congress. This court is devoted to a very kind of aggressive agenda in expanding federalism, which means they're much more inclined to say the states have the right to be free of federal mandate. And so federalism and state-federal relations are much more at issue as here. It's interesting, in the original Affordable Care Act case, the vote to uphold the mandate was 5-4. The vote to overturn Medicaid and to say that the federal government went too far was 7-2, including one of President Obama's appointees. So there was something about the Medicaid expansion that didn't just offend the 5 justices appointed by Republicans. There were 2 Democratic appointees in that as well, and people sometimes forget that split on the court. So here's a prediction. Supreme Court, in an opinion by Justice Roberts or maybe Justice Kennedy, will or maybe will not uphold the subsidies in federal exchanges. The reason will be that the majority will look or not look at the record as a whole and apply traditional statutory rules of construction. On the other hand, I really don't have a clue what the court will do. I think it will be, for the reason you articulated in your question, it will be a hard thing for the court to take 11 or 12 million people off insurance, whether they, now you can, on the other hand, you're on the Supreme Court, right? You can say Congress can fix it. Congress in a normal world would have fixed this statute as a technical amendment to the ACA as soon as it was raised. You can fix this by doing what I said, an exchange or a federal or state exchange. This is so easy. It's a technical amendment. But that's not what this issue is. It's a hugely divisive issue. So, I mean, I believe in the end it's purely wishful thinking. It's not an informed, it's just wishful thinking, that the court will find a way to uphold the subsidies. The key justice, it's assumed, will be Justice Kennedy, and the argument that was really pitched at him during the oral argument and pitched at him by Justice Sotomayor was a federalism argument. Because what may ultimately appeal to Kennedy is less of a concern about 11 million people losing insurance and more the argument that goes this way. If you can only get a tax break, subsidy through a state exchange, not through federal, then it forces the states under a federal law to create exchanges, which violates his very strongly held notion the federal government should not mandate the states to create new structure. So that argument may in the end save this. There's a worst case analysis in which the court ends up invalidating subsidies under either exchange, but that would be a whole new world, all right? But again, Justice Kennedy and Justice Roberts are the key. You know exactly, I mean, you can predict 4 justices over here, minimally 3, probably 4 over here, and then Kennedy or Roberts. Now, abortion rights. Some of you, well, I'm looking around the room, maybe nobody. I remember when Roe versus Wade was decided. Most of you have grown up in an environment where it was sort of taken for granted. Roe versus Wade, of course, is a case in which the Supreme Court invalidated a criminal statute that made it a crime for a doctor. It subjected the doctor to prosecution for performing an abortion. A Texas case was decided in 1973, and the court at that point articulated what it characterized as a trimester approach. Trimester would mean what? It's a tricky question. Tri from the word meaning, which would correspond to terms, which would be how many months of a pregnancy, Within the first 3. Let me just say, it's very sad that I have to rely on the dean for these answers. The rest of you are going, I don't know, is it time for class yet? I don't know. So when Roe was decided, it really fit a couple of different things. One, where sort of technology was at the time in terms of being able to maintain, for a fetus to become viable outside the womb. 2, it was sort of a neat structure analytically, because the court just made this up, right? There was no, abortion was criminalized in most states, almost all states. And so think about the map I showed you of same-sex marriage and the radical, it's a radical shift culturally and socially, and we shouldn't sort of pretend it isn't. So the Roe case struck down the laws of scores of states. Now the Supreme Court at that time had come off 18 years in which it had decided Brown versus Board of Education, which invalidated what had been in the United States a legal structure of apartheid that was the same as the legal structure for apartheid in South Africa, based on a Supreme Court case in the 1890s that said it was legally permissible to maintain separate facilities based on race. Supreme Court struck that down in '54. They spent the 60s expanding the rights of criminal defendants. Then they announced the abortion decision. 2 years later, they stopped all capital punishments in the United States indefinitely based on a decision which at its core was this. There's only a handful of executions in the United States each year. There's no rational basis that we can figure out for why certain people get executed, except they almost all seem to be black. And so it's so idiosyncratic. So that's quite a run. for the Supreme Court. So again, contextually, this is not the only era in which the Supreme Court's been controversial politically. So Roe comes down with the trimester, but there's two weaknesses. Well, Roe also cites St. Thomas of Aquinas. He was probably very happy that he'd been cited in a Supreme Court opinion because St. Thomas Aquinas used the phrase, the quickening of the womb. So this is one of the weaknesses textually of the Roe case, which was criticized almost immediately by legal scholars for the way it was articulated as much as it was socially for what it unleashed. Textually, if you're citing Thomas of Aquinas as the basis for the articulation of a new constitutional right, you may be a bit on thin ground. Maybe Augustine's the guy you want, but not Thomas. Second, this is a long decision, there's a paragraph in the case that to legal scholars became quite significant, in which the court said, this is based at some level on the right to privacy. The Constitution doesn't mention privacy, and then it goes on to talk about several amendments right to privacy might exist. And then it used the phrase, the penumbras of the Bill of Rights. So this, I won't ask you what penumbras are. I think they meant to say penumbrae, as somebody who had 4 years of Latin, but that's different. So it was a textually weak case in that sense, because they based it on a right to privacy that had no basis in the Constitution, other than the court over time had gradually created it. Now, Brown versus Board of Education is even weaker textually in the sense that Brown versus Board of Education cites no legal opinion except the Supreme Court case from 50 years before it overturned. But there you had a constitutional commitment to equal protection based on race. So abortion was a controversial decision from the start. The court has gradually weakened the right over time. The basic, for 20 years, any restriction on abortion access in the first trimester was immediately struck down by the federal courts as violating sort of this trimester approach. The court in 1992 did a case called Planned Parenthood versus Casey, in which they moved away from Roe, said there's still a basic right, but they validated 4 restrictions that Pennsylvania had passed in the first trimester. So that was an enormous departure from law. Justice Roberts, when he was Solicitor General, which is the position in the government that argues for the government in Supreme Court cases, Roberts said, this was, I believe, the first Bush. It's hard to keep them all straight. At one point we had a Bush president, we had a Bush governor in Florida. There were a lot of Bushes. We continue to believe Roe versus Wade was wrongly decided and should be overruled. Now, he was reflecting the administration's position at that time, which is what you do as Solicitor General. Supreme Court's conclusion in Roe, there's a fundamental right, finds no support in the text, structure, or history of the Constitution. Now, a few years ago, when the Supreme Court was asked to validate a right under the Constitution of physician-assisted suicide, Supreme Court unanimously said there was no right to that because, based on the text, structure, and history of the Constitution, there had been no evidence that anyone everywhere had said suicide should be legally permissible. So the court takes very seriously these 3 things. Justice Roberts now, of course, is the Chief Justice of the United States. And Roberts clearly has articulated his position on this issue. Now, the other thing to think about, I was going to make this like one font so none of you vaguely know there's something on the screen, but what it was, who would know? You can explain the history of the evolution of the right to abortion by these 4 things. This is Roe versus Wade, 1973. 7 justices, they disagreed on the ground, but 7 justices found there was a fundamental right on constitutional terms for a woman to terminate a pregnancy. Planned Parenthood was the case everybody thought would end abortion rights because President Bush had appointed a justice named Souter, about which, when reporters went and looked him up, they could find only 2 things. One is that he lived with his mom. The second, he rode his bicycle to work. But that was literally it. That was all they had. Because he had originally appointed this guy, Robert Bork, who had spent years writing law review articles to try and get on the Supreme Court. When he went in front of the Senate confirmation panel, they crucified him based on his own writings. So the response was, well, we'll find somebody who's never written anything about anything. So what they didn't understand, apparently, was Souter had spent some time representing a teaching medical center. Just as Blackmun wrote the original case in opinion of Roe versus Wade, because Blackmun had been the general counsel of the Mayo Clinic, and in his view, and he was actually, he said in several interviews after Roe, surprised, first of all, that he then had to live with bodyguards the rest of his life because of the death threats, but second, his view, and this may just be that Supreme Court justices are a bit isolated, to him abortion was just a medical procedure. And so he didn't understand what they were sort of unleashing. But in Planned Parenthood, Souter, O'Connor, and Kennedy announced that there's still a right of access to terminate a pregnancy. They're going to modify it by permitting these first-term restrictions. But their fundamental view, which they say from the bench when they announce their opinions, is that they think it would undermine and eventually destroy the credibility of the court if the court overturned fundamental decisions based on changing composition of the court. And it had only been 20 years since Roe. So that was sort of this notion that, as radical as Roe was, that the court should approach change on fundamental tenets sort of very incrementally. But look at the votes, right? So now it's 5 votes to 4. You have Scalia and Thomas, who've been on the court for 14,000 years. Thomas was actually 17 when he was appointed by Justice Bush, so he's going to be on the court. And still has never asked a question from the court, because that's not what he does. But it's now 5-4, right? So 7-2, 5-4. Kennedy's still here. You then get to Stenberg. Stenberg was a case in Nebraska in which a particularly gross sounding form of partial birth abortion was banned. And it was challenged, and this is where I believe abortion rights advocates overplayed their hand, because the thought was any prohibition of any procedure will inevitably undermine the entire structure. What happened, though, was by challenging the Nebraska statute, they flipped Justice Kennedy's vote, because he was so offended and made clear in his opinions, he's so offended by the practice, the particular technique, that he flipped his vote. Only justice in the sort of evolution of abortion law who's changed his vote. So Kennedy voted to uphold the statute. Still 5 justices who vote to strike the statute down because, in part, it did not account for an exception for the health of the mother, only the life. And from Roe forward, any restriction on abortion had to account for an exception based on the health, endangering the health or life of the mother. So Kennedy flips his vote. You then get to the Gonzalez case. The Gonzalez case was, Congress was then controlled by Republicans in both houses. They passed a statute that President Clinton had vetoed repeatedly, which outlawed that same type of partial birth abortion as a matter of federal law. It's challenged again. This does not contain an exception for the health of the mother. It goes to the Supreme Court, and for the first time since Roe, a majority of the Supreme Court upholds a restriction on a particular technique for abortion. That's the first time they've done that. Second, they are unconcerned that there's no exception for the health of the mother. That's a radical shift in abortion law. And again, whatever side of the issue you're on, from here to here is a long way, and it's entirely because Kennedy flipped his vote because of how offended he was at this particular technique. So here's where we are. There's 4 justices, Sotomayor, Kagan, Ginsburg, and Breyer, who would vote to uphold whatever it is that's left of the right to terminate a pregnancy. Roberts, Scalia, Thomas, and Alito would strike it down at lunch if they could. They're very explicit. They think Roe was badly decided. They think it was a mistake, that, as Roberts said, it has no support in the history, text, or structure of the Constitution. And the swing vote, and you've heard this name before, is Justice Kennedy. Now, what's happened since, and again, remember, from Roe through here, every first-term restriction ever enacted by any state legislature, and they were very tentative because they knew what the law was, got struck down. This is states that have, these are states that ban abortion in the third trimester. There's all these there's 8 states now considering or have enacted legislation that would say, as a matter of state law, personhood begins at the moment of conception. Now, that's critically important from a legal point of view because the Constitution does not protect fetal life. The Constitution protects persons. So if whatever it is that is in there at the point of conception is a person, then if you have an abortion, what does that do? Legally, what is that? It's murder, right? And that's where abortion sort of began in a sense. So Planned Parenthood opened up the ability to restrict in the first term, and these are all the states that are passing laws. There's also increasingly legal efforts to impose all these onerous requirements on the few facilities left that do abortions. There's also been violence, as you know, doctors killed who do abortion. No medical school trains in abortion techniques. This is why, for those who keep track of this, who care about this, which probably some of you do, it's why the focus is now shifted to contraception. Because if you truly believe conception is the creation of a person, that was the debate over the morning after pill. That was Hobby Lobby. That certain types of conception are effectively abortion. And remember where we started back in the early 60s with all this sort of right to privacy and all this began, a case involving a Connecticut statute that made it a criminal act to possess contraceptives in your home. So again, I think many of you grew up in an environment, Roe versus Wade was ancient history. Roe versus Wade, it was articulated, no longer exists. There have been about 1,600 legislative proposals in different states to restrict abortion, to make it more onerous to have one. Virginia a few years ago had its mandatory transvaginal ultrasound bill. One of the Virginia legislators then introduced legislation in response saying for a man to have prescription Viagra, they should have to have a rectal and cardiac exam before, but that didn't pass. So this was Kennedy. The government, this is in the PartialBirth Case, the government may use its voice and authority to show its profound respect for the life within the woman. Ginsburg said, this decision cannot be understood as anything other than an effort to chip away at a right declared again and again by the court with increasing comprehension of its centrality to women's lives. So Ginsburg gets that how precarious, and that's the point of this as well, how precarious some of these things are. It's one thing for a court to create a new right, but one thing a court can do is take away that right. And it's rare in our society, but it does happen. And again, the most significant example is the case in the 1890s where the Supreme Court said apartheid was constitutionally permissible, to the Brown versus Board of Education, to where we are now 50 years after Brown, where a majority of the court is determined to make the Constitution entirely race blind. There will be no affirmative action that's legally permissible based on race or any race-based distinction. Now, on the one hand, that's what the Constitution in fact talks about, right? It's the Constitution with the 14th Amendment tries to be race blind. Affirmative action was created and endorsed by the Supreme Court, at least in limited terms, to try to remedy historic wrongs, but we are moving to a point where the Constitution truly will be race blind, and you won't be able to do anything theoretically negatively or positive based on race. So I think the court won't yet overturn Roe, but it will increasingly approve stringent regulations for abortion providers, and as a matter of fact, whatever the court does, because Roe has basically been eviscerated. Roe doesn't exist anymore, as it did. Once Planned Parenthood was decided in '92, once this court consolidated its majority on this issue, once Kennedy flipped his vote, then the ability to restrict access grew exponentially. It's not just the personhood legislation. In North Dakota, it is no abortion is permitted except after 6 weeks, which they tie to, now they don't use Thomas Aquinas, but sort of development of, you can see a heart and what have you, right? And technology to some degree has made abortion increasingly difficult to sustain because people can see inside. And so North Dakota ties its statute to what we can now learn about fetal development from technology. But they also say an abortion will only be permissible after 6 weeks based on the serious physical threat to the life of the mother. And even in that case, it's banned in the case of incest or rape. So let me just say this. North Dakota is not the place you want to do conception, unless you're going to get out of there within 6 weeks, all right? So that's the sort of state of the law. And I don't mean, this is not like a Fox News, the apocalypse is coming with every sort of story. But I mean, this is a very, very precarious sort of thing. And again, I think in real life, in at least 24 states, abortion rights are fundamentally gone. And it's just a question, at some point the Supreme Court can just let it ride and just let these restrictions pile up. The reason the North Dakota statute hasn't been challenged is because people are afraid to, because they know that this is the Supreme Court today. So if you're challenging these onerous restrictions, once you run the risk, because you can see that Kennedy's down here now, Kennedy sides with these 4 folks, and then it doesn't matter that Roe's gone. If restrictions like North Dakota are constitutionally permissible, then there's no restrictions that aren't. So that's that case. And then finally, medical marijuana. Now we turn to a nice subject, right? So again, these states are states that either have approved or were on the verge of approving cannabis. It's a different issue than legalizing cannabis more generally, but there's something to remember. This is a Supreme Court case in 2005. Congress may criminalize activity, production of cannabis in states that have approved it for medicinal purposes. This again gets to this notion of which part of government controls, sort of has authority over an issue. And so during W. Bush's administration, they went aggressively after cannabis growers in California. The Bush administration also challenged the Oregon physician-assisted suicide law on the ground that the agent of death in that state is a drug that's regulated by the federal government. So again, these are a lot of issues of federal-state authority, and they eventually withdrew that challenge after people said, surely you're kidding. But this is the issue. Is hemp a controlled substance or an agricultural product? Now, one of the things we're proud of in Indiana, Nan and I grew up, again, we have many things to be proud of. Dan Quayle, perhaps the only vice president who misspelled a word on national TV. Bobby Knight, who got fired as a most successful coach in basketball history, but he choked an athlete. And now our most recent invitation to gay couples to come to Indiana and have their weddings catered by Pizza Hut. But Indiana grew a lot of hemp during the war, during World War II, because that was used to make rope. So hemp has a lot of sort of agricultural purposes. But under the Federal Controlled Substance Act, it's regulated still as a Schedule I drug. And under terms of Schedule I, it's considered unsafe to use under medical supervision. So federal law, as written, is antithetical to the legalization of use of cannabis for medical purposes. Federal law on its face says it's unsafe to be used for that purpose. So a lot of the advocacy, and there's a bill in front of Congress now that would move cannabis from Schedule I to Schedule II, which is a different criteria which you can then use under medical supervision. So this issue, again, part of this as well, the point I'm trying to make here is sort of what turns these really important decisions that affect millions of people is often it's a vote on the Supreme Court. It's sort of historic regulation of a drug that for 50 years people have been reluctant to disturb the classification for political reasons. It's somebody didn't write or add 2 words in the most important health bill since Medicare. So these are minor things that turn these potential cases. So healthcare access, just to summarize, depends in large part on 2 of 9 justices who are appointed for life, who get their health care through the federal government. It was really great when Ted Cruz, who I know I'm going to do an organizational thing for him later outside. I want you to all give money. I know James Herbert will be all over that.
Oh, yeah.
So Ted Cruz announces for president, so his wife has to quit her job to join his campaign, so he has to get insurance through an exchange, right? And he's tried to get the ACA repealed 1,000 years. So I'm hoping the Supreme Court will uphold the subsidies except for insurance bought by a senator running for president. I think the things we take as permanent aren't necessarily, right? Because the issues I've talked about are all sort of discussed, thought about, judged on, legislated on in the context of huge kind of social, cultural sort of debates. There's hardly consensus on any of these issues. And that lack of sort of consensus kind of roils the sort of way the issues get decided by legislators or judges. It's astonishing, again, to me, how rapidly public opinion on same-sex marriage has evolved. That's virtually unprecedented. It's why the Indiana law got pushed back that it wouldn't have gotten 10 years ago. If you think back to W's, one of his campaigns, Karl Rove put all kinds of bills on the ballot that year in different states that would prohibit same-sex marriage to get the vote out. That would not work as well today in most parts of the country, but these are very sort of tenuous advances from a legal point of view. I really don't see any way the court won't validate same-sex marriage, but they might not. They might decide in the end. I think the main reason they can't do that is just that it would, again, be chaos with sort of folks who've been married in 37 states under this now. So, and elections matter. I mean, these are all like civics 101 things, as someone said, but W won Florida, sort of, by 500 votes of the votes that were counted in his first election. That flipped all this stuff, right? If Bush isn't elected, if Gore is, Justice O'Connor, Justice O'Connor would have been replaced by a more moderate judge. She was replaced instead by Justice Alito, who's every bit as far to the right as Scalia and Thomas. O'Connor resigned from the court because she felt like she had to take care of her husband who had Alzheimer's. Her resignation is absolutely pivotal in how a number of these cases will turn out, because she would have voted against Hobby Lobby. She would vote for the health subsidy. She would vote to preserve some notion of right to terminate a pregnancy. So that matters. And then the Constitution continues to evolve. I mean, again, think about what we're talking about here. In virtually all these cases, we're talking about rights that at least at some measure were shaped, in some cases absolutely created or uncreated, based on a Constitution that was written 200 years ago or 250 years ago that doesn't contain language that would really textually tell you how to think about any of these issues, but it's based on things like not discriminating based on skin color, the equal protection of the law, not sort of you get more than I do because you're white, you're whatever, but it's equal protection of law. The notion of privacy, which has become fundamental in our legal system in terms of constitutional law, which really only got some traction when it came to a majority of the court in the 60s that began to push at kind of control of individual conduct. So these are all significant cases, and they're all really vastly important in terms of population health. The court will know on the same-sex marriage case and the health subsidy case, if they don't announce it before, certainly by June, after the term and after the cases are argued, they'll announce their decisions, and then we'll see what happens. And then, as I said, if I'm right, send me the emails, but if I'm not, send them to my sister. So, Dean Williams, thank you so much. Questions?
a few
Absolutely.
questions?
Any questions? I'm happy to have questions, comments, counter predictions.
I want to see that whole legal
Yes.
thing.
The whole legal thing, right?
Hear more about this idea that corporations have a right to religious freedom or whatever.
I have to take my coat off for that part. All right. So here's the issue. So historically, you had, and I'll try not to be too pedantic, but I can't help myself. So I take my coat off, I'm going to be really pedantic. So you have individual rights, right? Corporations are a legal structure created by state law, common law in England, state law. Corporations had privileges or rights created by state law. Everyone incorporated in Delaware, because in Delaware you got the best breaks in terms of your tax structure, corporate organization, et cetera, et cetera, et cetera. So then two things happen. One is, over time, the Supreme Court begins to expand how it thinks about free speech. So I actually will bring this back to. So a case goes to the Supreme Court and says, it's a matter of political speech to burn a flag. The majority of justices say, that's right. Free speech, as it's articulated in the First Amendment, is as much about political expression as it is anything else. Burning a flag is political expression, therefore that's free speech. But burning a flag is also what? It's conduct. So you get a bit of a departure from the notion that speech is just speech. It can be conduct. But it's also political expression, is sort of the emphasis. Eventually you get to campaign contributions and limits on campaign contributions. Giving money is not necessarily speech, right? It's conduct. But if the First Amendment is designed to protect political expression, and if we're going to define speech in a way to maximize political expression, then political contributions must be free speech, and therefore government's ability to restrict them is very limited, because it's very limited ability. Free speech is kind of important. Not as important as the Second Amendment, but it's up there. So that's one strand. Second strand is that this court is the most business friendly court of all time. Since, it just is. It's not a criticism, it just happens to be. This court hears about 60 cases a year, or has heard, instead of 80, because criminal defendants no longer bring cases to the Supreme Court. Because you think it'll just be, who knows what they'll do next. So, because they're clearly interested in retrenching on some issues. So it's a very business-friendly court. Lots of businesses give money to campaigns. So businesses, they're kind of exercising their right to free speech. Citizens United, or United Citizens, whatever, right? The one that basically stripped all restrictions on campaign contributions, I think is the most dramatic case the Supreme Court has decided, probably since Brown versus Board of Education, but for entirely different reasons. Because Citizens United effectively ends the ability to regulate campaign contributions, and eventually at a state level. Why? Because it's free speech. And two, because it begins thinking about corporations as having constitutional rights. Now, there's some constitutional rights in terms of regulation, et cetera, et cetera. These are more sort of affirmative constitutional rights to free speech. You then get to Hobby Lobby, and the court doesn't say all corporations, but it talks about a particular type of incorporation that they talk about in that opinion how this is basically just individuals using a corporate structure, but it's still really a personally held corporation. So they, to some degree, take what's literally true, which is that a corporation is sort of a legal structure designed to effectuate different things by groups of people, but they take that and sort of turn it on its head and say those people who've now incorporated themselves retain the rights they held as individuals. And therefore, those people in the form of a corporation, the corporation now is effectively expressing their political views. back to free speech. And that's why this issue of, and they used the statute, the Religious Freedom Restoration Act, which was enacted by Congress in the 90s, and Congress was trying to expand religious expression. They marry that to this expanded notion of corporations as people, and effectively meld the two and give corporations, in some context, the right to exercise their religious beliefs. Now, there's always been that tradition in terms of churches and other things, right? So, but this goes far beyond that. And I think it's a doctrine that Supreme Court justices 40 years ago would have gone, huh? Say what? I mean, because it's a big jump in our law. This is the same split, it's 5-4. So, and if you read the opinion in the Hobby Lobby case by Alito, it's very much, this is just incremental, this is based on past precedent, et cetera. You read Ginsburg's dissent, it's like, you wouldn't know they're talking about the same case. Ginsburg's like, or the same body of law. Ginsburg's like, this is such a radical departure. Now, it's interesting in that case, and this is why I talked about sort of the open question of if same-sex marriage is effectively made a constitutional right on the ground of equal protection of law, will this religious freedom notion sort of impinge on that? Because in the Hobby Lobby case, the court says, and they choose words very carefully, this opinion in no way validates discrimination by corporations based on race, period. So that's deliberately chosen. And one of the things, when I talked about the opinion to a couple TV stations in Tampa that I pointed out was they very much leave open, but can you discriminate on the basis of sexual orientation? And that's the open question. So you got these two kind of strands of opinions in which Kennedy's sort of definitively pivotal in both. So it'll be interesting. I mean, I think the right thing is, it's all of a question, do statuses or, in this context, sexual orientation, do they rise to the same level as race as being constitutionally suspect if you try to discriminate on that basis? Race, again, has a textual basis in the Constitution. Sexual orientation does not, gender does not. So if you don't have those in the text of the Constitution in the 14th Amendment, you rely on the courts to gradually adjudicate cases in ways that eventually give those either gender or orientation that similar status. If you don't have, if gender, orientation, what have you, doesn't rise to the level of race as a constitutionally suspect classification, then things like anti-discrimination laws don't necessarily apply in the same way they do to race. So it's a subtle kind of set of legal principles, and those are subtle distinctions that have long history. My mentor in law school at UVA, I was in law school, I went to UVA right after the Civil War ended. It was a long time ago. I met Jefferson once, it was really interesting, but at that point in the 70s, there was an effort to pass the Equal Rights Amendment. Any of you remember the Equal Rights Amendment? It would have a constitutional amendment to ban discrimination, to make gender the same as race, to amend the Constitution. The guy who taught me constitutional law, who's probably certainly in the top 1.5 of the smartest people I know, Richard's advice to the National Organization of Women at the time was, you're making a mistake, because the Supreme Court over time is eventually going to elevate gender to the same status as race. But if you try and enact an amendment and it fails, the Supreme Court will say, well, you subjected it to the will of the people, obviously you couldn't get the votes, so we're not gonna. So there's a lot of different sort of what's the venue, what's the strategy, what's the argument. All right, that's a long-winded answer to the question, but it's a real big departure in terms of kind of existing doctrine about how we think about corporations' expression of rights. I told a friend, if corporations have a right to religious freedom, they probably have a right to bear arms, and then everybody will have their own private. So you go to 7-Eleven, they got their own little private army out there, it'll be great. Second Amendment rights. I mean, the thing, once you start down this path, it's not clear where the boundaries, when do you reach an end point in terms of corporations have the same rights people do. So it's just an interesting, and again, Justice Alito, who wrote Hobby Lobby, would say that's completely exaggerated view. You know what you're talking about. You're not on the Supreme Court. I am. Justice Ginsburg would say this is a huge departure. So how big of a departure it is will turn on what the court looks like over the next few years. If you don't vote for any other reason, regardless of your political views, if you only have one reason to vote, vote because the next president gets to. Right now, President Obama, so far in his term, the Republicans will filibuster any appointee to death if it would shift the balance in the court. But some of these folks, Ginsburg can't possibly go another 4 or 8 years. Scalia hopefully can't go another 4 or 8 years. Justice Kennedy's old. Breyer's frail. Breyer was hit by a car riding his bike to the court. I mean, he could, so it's like, if nothing else, this talk should get you to think about it's that the presidential elections matter. And if they matter for nothing else, they matter for this reason, because this is a Supreme Court. Justice Earl Warren, who wrote Brown, held the opinion for 2 years because he wanted the court to be unanimous. This court's never going to be unanimous on these things. It's just 5-4, 5-4. So, all right, any other questions? I'm happy to take questions, comments, thoughts. People are like, really, it's that precarious, these things we thought were rights?
Well, you know.
But it's just the way it is, right? So
Politics is always a touchy issue.
politics is a touchy issue.
All right, well.
I tell my students, I don't care if you care about health policy or not, but if you're going to go, my students are going to go manage healthcare systems, you better at least know it's out there, because you'll get killed if you don't. Because healthcare is 20% of the gross national product. We're still in an era, I think eventually we may end up with 7 or 8 major companies nationally with lots of boutique providers. You got to know, I mean, this stuff affects population health, as does lots of other stuff. So
Thank you.
it's been a great pleasure. Thank you.
Great job.
It was enjoyable.